Hey everyone, it's me, Leonard French, your favorite copyright attorney, here with the news about your favorite suspended copyright troll attorney, Richard P. Liebowitz. It seems that the hammer of justice is not quite done with Mr. Liebowitz, who was indefinitely suspended from the practice of law by the state of New York last November, while the Federal District Court for the Southern District of New York was completing their investigation of his professional misconduct. See, there are standards for attorneys called the Rules of Professional Conduct, and Mr. Liebowitz broke those rules many, many times. Judge Jesse Furman of the Southern District of New York had documented at least 40 instances of professional misconduct or otherwise sanctionable behavior on Mr. Leibowitz's part. I did a video on that situation. I'll post a link in a bubble. But just because Mr. Liebowitz was suspended last November doesn't mean that his cases are immediately over. There are still open cases where courts are considering sanctions motions or other discipline against Mr. Liebowitz. One such case is in the District of Colorado in Miller versus Bahakel or Bahakel Communications. Miller, through Liebowitz, had sued Bahakel Communications for using a picture that Miller took of comedian Tracy Morgan after the 30 Rock star had a fender bender in his Bugatti convertible. Miller accused Bahakel of using the pictures on its news website without permission or license. But the Miller case quickly ran into major problems when Bahakel explained to Liebowitz that it is a company organized under the laws of North Carolina and headquartered in Charlotte. Liebowitz had filed the Miller case in the District of Colorado, possibly to avoid scrutiny in North Carolina, or maybe he expected a quick settlement regardless of jurisdiction. But instead of a quick settlement, Liebowitz got opposition from Bahakel in the form of a motion to dismiss for lack of personal jurisdiction. But while the motion to dismiss was pending, the court was notified of Leibowitz's inability to practice before the Colorado court in light of a disbarment order issued by the Northern District of California in October of 2019, which is another Liebowitz story I covered. I'll put a bubble up in the corner. Liebowitz attempted to file an amended complaint, which was denied because he was now prohibited from practicing before the bar of the District of Colorado Court. Liebowitz moved to withdraw from the case, and the case was voluntarily dismissed. Defendant Bahakel then moved for sanctions. Lawyers are not supposed to file cases without having a non-frivolous basis for doing so, meaning they must do some basic diligence into the grounds for a lawsuit and the truth or falsity of the plaintiff's claims. By filing a lawsuit without establishing a good case for jurisdiction, Liebowitz had violated Federal Rule of Civil Procedure 11, which allows for sanctions against parties or attorneys that file pleadings or motions or other papers for an improper purpose. On February 19, 2021, the court issued its order granting defendant's motion for sanctions against plaintiff and his counsel. In the order, the court determined that plaintiff Robert Miller failed to establish a plausible basis for personal jurisdiction over defendant Bahakel Communications. Moreover, the court observed that attorney Richard Leibowitz's strategy of filing copyright actions in an inappropriate venue and without a basis for personal jurisdiction is not unique to this case. As a result, the court determined that Leibowitz's conduct warrants sanctions and ordered Liebowitz to show cause why the court should not impose sanctions for his bad faith and vexatious conduct. Liebowitz argues, among other things, that to the extent the court determines that monetary sanctions are warranted, they should be limited to the reasonable attorney's fees incurred by defendant in briefing the venue issue at defendant's motion to dismiss hearing. Defendant filed a supplement with supporting documentation, which separately explains the amount of the attorney's fees and costs incurred in 1. Litigating this case in its entirety, 2. Litigating the venue issue in this case, and 3. Filing the motion for sanctions and the fee supplement requested in this order. The court notes that Liebowitz did not seek leave to file a response to defendant's supplement with supporting documentation. When determining the amount of a legal fee award, the court must provide a concise and clear explanation of the reasons for the award. The court has discretion in calculating the award, and the court's focus should be on the reasonableness of the fees to be awarded. Hello, would you like to say hi? would you like to say hi? No, not really. No, not really. Okay. Now you're stuck. Get off. You're stuck. Pulled pulled threads out of my. That's what I get. That's what I get. The court has discretion in calculating the award, and the court's focus should be on the reasonableness of the fees to be awarded. The starting point for calculating reasonable attorney's fees is determining the lodestar amount, that is, the reasonable hourly rate multiplied by the number of hours reasonably expended. The court may consider the facts and complexity of the case, strategies used, and responses necessitated by opposing parties' legal maneuvering. Regarding the hourly rates charged, the court should base its award on market evidence of attorneys' billing rates for similar litigation. Market evidence for lawyers with similar skill and experience in the relevant practice areas will inform the court's decision on billing rates. The basis for sanctions against Richard Liebowitz relates to the question of Leibowitz's decision to bring a case against defendant in an improper venue. Defendant states that it incurred $7,952.50 in litigating the venue issue in this case. This figure represents 30.2 hours expended by two timekeepers. First, Patrick Cross, and second, Eric David. Mr. Cross's fee rate in this case is $245 per hour, and Mr. David's fee rate is $380 per hour. Mr. David is a graduate of the University of North Carolina School of Law and has been a member of the North Carolina Bar since 2008. His practice as a partner with Brooks, Pierce, McClendon, Humphrey, and Leonard LLP primarily focuses on complex litigation related to intellectual property, media, and the First Amendment, and general business matters. Mr. Cross is a graduate of the University of North Carolina School of Law and has been a member of the bar since 2016. Mr. Cross was a law clerk for the Honorable Janice L. Sammartino of the United States District Court for the Southern District of California from 2016 to 2017, and the Honorable James A. Wynn Jr. of the U.S. Court of Appeals for the Fourth Circuit from 2017 to 2018. Mr. Cross's practice primarily focuses on telecommunications, intellectual property, and complex business litigation. To support its fee request, defendant submits Edward Stewart's declaration in support of Bahakel's motion for sanctions. Mr. Stewart is a partner at the law firm of Wheeler Trigg O'Donnell LLP and was engaged to provide his opinion regarding the reasonableness of the attorney's fees charged by defendant in this action. Mr. Stewart was admitted to practice law in Colorado in 1994 after working at a large full-service national law firm based in Chicago. He practices civil litigation, including trial and appellate work involving complex commercial litigation, product liability, and personal injury litigation. Based on the foregoing, among other things, he states, he is familiar with the range of attorney hourly rates routinely charged for handling complex commercial litigation in Denver. Mr. Stewart cites a District of Colorado patent infringement case in which the court found persuasive a survey showing Denver law firms billing between $285 and $810 per hour for partners and between $170 and $540 per hour for associates. Additionally, Mr. Stewart relies on his own firm's standard billing rates for 2020 and 2021, in which partners charge standard hourly rates ranging from $455 to $850 per hour in 2020, going up to $885 per hour in 2021. Based on the foregoing, Mr. Stewart opines that Mr. David's $380 hourly rate and Mr. Cross's $245 hourly rate fall well within the range of reasonableness for the Denver market nearly a decade ago, and are well within the range of reasonableness, or even are lower than Mr. Stewart's own law firm's billing rates in Denver. The court agrees with Mr. Stewart's analysis and finds that both Attorney David and Attorney Cross's hourly rates are reasonable in the Denver market. Next, the court examines the reasonableness of the number of hours billed. In litigating the venue issue in this dispute, defendant states that its lawyers expended 30.2 hours. Mr. Stewart's declaration also addresses the reasonableness of the hours billed. He states that the division of labor between Mr. David and Mr. Cross was reasonable, and they ensure that they were representing defendant's interest in a cost-effective manner. Mr. Stewart quotes the court's order, which noted that the underlying case involved a notorious opposing counsel whose strategy of filing copyright actions in an inappropriate venue and without basis for personal jurisdiction is not unique to this case, and that Liebowitz's pattern of bad faith and vexatious conduct likely warrants judicial action. Mr. Stewart observes that this case represented an attack on defendant's core business and a real threat of repeated and perhaps voluminous lawsuits if not vigorously defended. Mr. Stewart reviewed defendant's invoices. He opines that delegating the overwhelming amount of work to Mr. Cross at a significantly lower hourly rate than that of Mr. David was reasonable and cost-effective. It is my opinion that the rates and total amounts charged by Bahakel's counsel are reasonable for the Denver market for the calendar years 2020 and 2021, he says. The court, too, has reviewed defendant's invoices, which helpfully highlighted in yellow the time entries related to the venue issue. Based on its review, the court finds that the relevant time entries are sufficiently particular and related to the venue issue, do not reflect excessive block billing or redactions, and are reasonable in relation to the venue issue at hand. Based on the foregoing, the court finds that defendant's counsel's hourly rates and number of hours billed in relation to the venue issue reasonable. The court will award defendant's attorney's fees in the amount of $7,952.50. The court then enters the attorney's fees award against Richard Liebowitz and the Liebowitz law firm on a joint and several basis, payable by May 27th. This means that Liebowitz or his law firm are responsible for the money, not Leibowitz's client, Miller. While it might sound good that Bahakel gets its approximately $8,000 back, it spent more than that on the litigation. In his supporting documentation, Attorney David shows that Bahakel incurred approximately $40,000 in attorney's fees in litigating the dispute in its entirety. So Bahakel gets $8,000 back, but is out $40,000, a net loss of $32,000 thanks to Leibowitz's shenaniganery. No other punishment or compensation was visited upon Richard Liebowitz in the Miller versus Bahakel case. But other disciplinary action is still pending for your favorite former copyright attorney. The Southern District of New York recently published its decision regarding Leibowitz's suspension from that court system. I'll have a story on that for you shortly. And the state of New York was waiting to make its final decision regarding Leibowitz's license to practice law until the Southern District of New York published its decision. So maybe we'll hear from the state of New York sometime this year. Let me know what you think of Richard Leibowitz's shenaniganery in the comments below. Thanks for watching. Special thanks to my top supporters in May: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Gutbrodj, ShadowTycho, Earthbound Star, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsus.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.